Welcome once again to Lehto's Law. Here's Steve Lehto.
Haran sent me notes, and Steve, check out the story from Maine. And it's a great discussion to have because it harkens back to the story that inspired the lawyer dog sign. And you'll recall that years ago in Louisiana, a man was being questioned by police, and they said, you have these rights. What are your thoughts on that? And he said, I like a lawyer dog. And they questioned him, despite the fact that they had just told me the right to remain silent and the right to an attorney. And he said, I would like a lawyer dog. And they said, no, it wasn't lawyer, dog. He was asking for a lawyer dog, an actual lawyer dog. And since they don't exist, well, we can't provide one, so we just get to keep questioning him. And in Maine, the state of Maine, they have now ruled very, very clearly on this. What would have happened if that had happened in Maine? Now, you might say, but Steve, that's a protection in the Bill of Rights that you have, right? So why would it matter from state to state? Well, it turns out Maine's constitution is a little bit stricter than the U.S. on this topic. So the ACLU of Maine actually handled this case. Samuel Crankshaw wrote the story. Maine law court strengthens Miranda rights and protections from self-incrimination. The case is called State of Maine versus McLean, clarifies that police must obtain a clear waiver of rights during interrogations, expanding state-level protections, even as federal courts have weakened Miranda rights. So in other words, you've got the right to remain silent. You've got the right to an attorney. You have to waive those, as opposed to you only get them if you invoke them. You start off having them until you waive them. So when they say, would you like an attorney? And you say, I'd like a lawyer dog. You're not saying, I don't want a lawyer. The Maine Supreme Judicial Court ruled that police must secure an explicit waiver of the right against self-incrimination before questioning a suspect in custody without counsel. And they also must halt interrogation to seek clarification if the suspect asserts their rights ambiguously. The landmark ruling strengthens safeguards the right to remain silent and the right to counsel found in Article 1, Section 6 of the Maine State Constitution. So the ACLU of Maine filed a friend of the court brief in the case and presented oral arguments back in December of 2022. And this story is recent. It just takes forever. The case originated when a man appealed a trial court decision allowing statements he made in police custody to be used as evidence against him in a criminal trial. When he was brought to jail for questioning, he was read his Miranda rights. When asked by police if he wished to answer questions, he said, "Is there a lawyer here?" The officers responded no, and then proceeded to interrogate him. McLean's lawyers argued he did not waive his right against self-incrimination and was invoking his right to counsel by asking if there was a lawyer present. But the officers ignored that request. But again, the court is saying to waive your rights, you must explicitly do so. So if they simply say you have the right to remain silent and you don't say, I waive that right or something to that effect, they got to get a clear waiver from you. The law court agreed with Mr. McLean and reversed the lower court's order denying the motion to suppress. The court wrote that someone in custody must actually waive the privilege against self-incrimination in order for an interrogation to occur or continue. And it must be clear and unequivocal, like we require for all waivers of constitutional rights. I personally think the same thing should have been true in the lawyer dog case. And don't forget that the Louisiana Supreme Court actually said, no, we agree. There's no such thing as a lawyer dog. What else could he have possibly meant? So if you ask for a lawyer, dude, I need a lawyer, dude. Okay, bring in a male lawyer, because I don't think female lawyers can be dudes, right? We got to go find this guy a male lawyer, because he said, I want a lawyer, dude. The court added, if the waiver of the privilege is ambiguous, an officer must, before questioning, stop to clarify whether the individual is in fact waiving the privilege against self-incrimination. If, after a suspect waives the privilege, there is an ambiguous invocation of the privilege, including the attendant right to counsel, the officer must stop any questioning and clarify whether the individual is attempting to invoke the privilege against self-incrimination. If the privilege is being invoked, questioning must cease. And I've mentioned before, I watch these videos on YouTube of people being arrested and questioned, pulled over, and all this stuff. It's not uncommon. You'll see them read somebody their rights. You have the right to remain silent, right to an attorney, blah, 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 blah. Having those rights in mind, would you like to speak to me? I've seen someone actually say, well, should I speak to you? Why would I speak to you? And they have this whole discussion. And I've seen some police officers occasionally tap dancing around the line because you can tell the person's thinking to themselves, I shouldn't be talking to them, but they're talking to me. Will I get in trouble for not talking? That kind of thing. So the court noted that it is long held that the Maine Constitution provides greater protections against self-incrimination than the U.S. Constitution. This decision expands protections in Maine, departing from the U.S. Supreme Court's view that police interrogation can continue when a suspect invokes their rights ambiguously. The law court explained that the U.S. Supreme Court's view could disadvantage the most vulnerable members of our society, referencing research showing people who use more ambiguous speech are more likely to be of lower socioeconomic status, young people, people of color, immigrants, and women. And I've seen it before where they read them their rights, and they're reading off a card, you have the right to remain silent, having those rights in mind, would you like to talk to me? Well, what happens if I ask for a lawyer? Will it help my case if I talk to you? And some people don't know this stuff. And so in this case, the court is simply saying, you've got rights. You start out the baseline, the very, very ground rule that you have here. You have these rights. When you get arrested, you still have these rights. They even go so far as to inform you of your rights. And then they ask, would you like to waive those rights? But a lot of times they don't phrase it that way. They say, would you like to speak to us? Would you like to speak to us? And so the court here is saying that you start out with the rights, and you can only lose those rights if you unambiguously waive them clearly. And if it's unclear whether you did or not, you still have those rights. And I think that this is how the U.S. Supreme Court should also interpret the U.S. Constitution. I think most people would agree that if the Constitution says you've got these rights, you've got these rights. You should have these rights. But apparently they've been chipping away at it over the years. And, you know, what's interesting to me is a lot of people, I have this discussion with people, and they say, Steve, Miranda versus Arizona, how long has that case been around? It's been around quite some time, right? Over 50 years. Who here has not watched an episode of Hawaii Five-0, McMillan and Wife, Beretta, Starsky and Hutch, or Sanford and Son, or I'm just kidding. Who doesn't know they've got these rights? So do we really need to even bother reading people their rights anymore? I mean, they've got pre-printed cards the cops pull out to read the rights to people. You know, you'd think the cops have that stuff memorized, but they're being careful. But everyone knows this. Why is this still a thing? The reason it's a thing is that a lot of people who get arrested today, for instance, just today, there will be people who are arrested who've never been arrested before, never pictured themselves being arrested, had never imagined themselves in that situation. And so suddenly you're thrust into a situation you've never been in before. And despite the fact that portions of it will feel familiar because you've watched the TV shows I just mentioned, or I don't know, CSI or whatever, it'll be new to you. And there's a very good chance that you'll be overwhelmed by those circumstances to the point where you will forget that you have those rights. And it'll be very important for you to remember that you have them. So a police officer will remind you you've got these rights. And one of the things that goes along with the Fifth Amendment and your right against self-incrimination is that it can't be used against you that you invoked your rights. They can't do that. Believe it or not, in the old days, they could actually point to a defendant who didn't take the stand and say, that guy wouldn't get up and tell his story. Guess why? He's guilty. They can't do that. They can't do that. Okay? And so you get arrested. If you had an attorney present, the first thing they would tell you is, shut your mouth and keep it shut. Don't speak to them. What if they ask me my name? You can tell them your name. What if they ask me what I was doing tonight? Shh. Shut your mouth. That's it. Don't talk. Invoke your right. And the police, I've seen them tell people this. They say, well, right now we're still investigating. This is your opportunity to tell us what happened. And, it'll go a long way towards, making things right. It'll go a long way towards getting you convicted is what it's going to do. Shut your mouth. You have the right to remain silent. Use it. So I like this ruling. However, it is just in Maine. But the ACLU is heavily involved in this. Haran, thanks for sending it. The thing I'm reading to you from is a press release from the ACLU of Maine. And it's the court strengthens Miranda rights and protections from self-incrimination, pointing out that the court's now ruled that you've got these rights unless you explicitly waive them. And if it's ambiguous, the police are required to follow up and make sure it's explicit before they assume you've waived your rights. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The website you seek cannot be located, but endless others exist.